What's up everyone, it's the Law School Lumberjack here again with another video. Today we're doing another installment of our Contracts Law 101 series, and today I'm actually going to be dealing with a request provided by a viewer. So thank you very much, you know who you are and I really appreciate it. So the viewer requested that I provide a brief summary on how to answer contracts law exams in law school. And I think that's an awesome idea. I've been kind of going through the substantive law that you deal with in a law school course, but I think briefly running through how to approach a contracts law exam is a wonderful idea. So thank you to the viewer who brought that up. I really appreciate it. So now I don't want this video to be too long. So what I'm going to do is I'm going to provide 5 to 6 suggestions on how to approach a contracts law exam. Hopefully give some tidbits of advice that you can then implement when you're writing your contracts law exam in first year. The first thing I would generally suggest, and the first thing I would do when I was writing a contracts law exam, is I would read the question first. And by that I don't mean read the passage first or the fact scenario first. I would read what the professor was asking me to do first. So this usually was only a 1 or 2 line thing. It maybe took me 30 seconds to read, but it helped me frame my thinking in order to figure out really what I was looking for in the passage above. Oftentimes it could be as simple as, what advice would you give? In which case that's not going to be very helpful, but sometimes the professor might give you a little tidbit of information in the question itself that can help you figure out what area of contract law you're going to have to focus on. So for example, a professor might say, please advise the contracting parties whether or not this would be a valid contract. Well, this is going to be super helpful by reading this question first. You're going to be reading this passage asking, okay, are the elements of the contract met? Is this contract void ab initio? So by reading this question first, you may be able to get some information and frame your thinking before approaching the passage. Step number 2, and this may seem obvious, I recommend that you read the passage carefully. But not only do I recommend that you read the passage carefully, I recommend that you write down any salient points on a separate piece of paper to really make sure that you understand the facts and don't miss anything when you're answering the question. So many times I've had colleagues or people I know write the exam, walk out, and within 2 minutes say, oh goodness, I've totally forgot this one stream of thought regarding this one fact I had. And that was oftentimes because the student was rushing or was anxious and didn't write down that salient fact on a piece of paper. Tip 3, and it's really a supplement to number 2, what I recommend you do once you have all those facts is take a couple minutes and set down all of your issues. I actually recommend that with the issues that you write those down in the actual answer itself. So if your professor, using that last example I provided, says, please advise whether or not this contract is valid, I would actually say the following issues may prevent the contract from being valid. Issue 1, this. Issue 2, this. Issue 3, this. By doing that, you've essentially organized your thoughts, you've organized what you're going to say, and you've made it easy for the professor to give you marks. Additionally, by having all these issues set out, it's going to make your work seem a lot more polished, even if you have the same information as another student who doesn't set out those issues. Remember, in most law schools, you're being marked on a bell curve, so any incremental gain you have is going to be extremely helpful to your grade. Now, number 4, I recommend that you always make sure that you not only state the law, but apply the law to the facts and then come to a conclusion. So many times when a student's rushing in their heads, they're saying, okay, I know the answer, they say the law, and then they forget to apply the law to the facts. Make sure that if you're going to rely on a specific case, a specific law, a specific doctrine, ensure that you are applying all of the facts that relate to that to the law itself to come to your conclusion. In essence, it's the same as a math equation. Make sure that you show your work to get to your answer. Now, tip number 5, what I recommend students do is don't be afraid to think outside the box or think pragmatically. And so what I mean by that is this. If you're reading through your fact scenario and you go, oh, there actually was a way to get around this issue, don't base your entire answer on that one pragmatic idea. Make sure you answer the question, but as a little bit of an aside, maybe a 1-paragraph answer or a 1-paragraph aside underneath the answer to the question, I recommend that you put forward that pragmatic idea. I'll give you an example that actually applied to me. I was taking a secured transactions course in law school. So I was reading through this question and it dealt with a $10,000 loan that was secured against a vehicle or a trailer that ended up going across provincial lines. and ended up in Ontario. The question itself dealt with whether the provincial PPSA applied to that trailer that was now in Ontario. So I answered the question, but at the end of the question, I was thinking about it, and I said, you know what? It's a $10,000 loan. Is it really going to be worth it or economically efficient for you to sue someone in Ontario to hopefully recoup that $10,000? You're going to spend more money on legal fees than the loan itself. So I ended up putting that in the answer itself, and I ended up doing quite well on that exam. So what I recommend students do is don't be afraid to think outside the box, have a pragmatic answer, but in case that pragmatic, creative answer doesn't actually hit the nail on the head, make sure you answer the question in its entirety. Just put in that creative, pragmatic idea as basically a kind of conclusion to the answer, as it can sometimes really help increase your grade and set you apart from the other students who may be in your class. So I've now provided you with 5 tips on how to approach your contracts law exam. But before I sign off, what I'm going to do is I'm going to give you some rapid fire tips on things that you might want to look out for in your contracts law exam. Firstly, if someone brings up a weird characteristic about something, like for example, a red Corolla, make sure you keep that in mind when you're reading through the rest of the passage. Because oftentimes, if someone's bringing up a characteristic when they could have just left that characteristic out, it may be that that characteristic is important. Number 2, each contract in the passage is going to be there for a reason. So if you have one contract and that's it, just focus on that one contract. However, you may have one main contract and a bunch of ancillary contracts that branch off of that main contract. Make sure that you consider each of those contracts and some of the issues that may exist with those ancillary contracts. For example, are those ancillary contracts fundamental to the main contract itself, in which case the failure to satisfy that ancillary contract may actually cause a significant breach under the major contract, or are they more side representations that can be dealt with things like damages? But in any event, make sure that you at least address each of those side contracts when you're answering your question. Number 3, make sure that you pay attention to time. What I recommend you do before you write your exam is to look through the marks for each of the questions and allocate time accordingly. So let's say you have 3 hours to write your exam and you have 3 questions that are worth equal marks. I would recommend that you allot an hour to each of the questions. If you've got a 3-hour exam and one of the questions is worth half of the marks, I recommend you allocate 90 minutes to that major question. By doing that ahead of time and by being very diligent about keeping to your timeline, you're going to prevent yourself from missing out on a question later on. Let's say you allocate 90 minutes to a question and you really want to make it perfect, so you spend an extra 30 minutes on that question and are unable to answer question number 3, for example. Now, because you've answered number 1 in a decent amount of detail, it's going to be a lot harder to get those incremental marks by spending the extra 30 minutes answering the question. You may write an excellent answer and get some extra marks, but by leaving number 3 blank, you've essentially got 0 marks for that question. Because the law school exam is marked on a bell curve, if you can at least get in the ballpark of a correct answer on question number 3, you're going to get a decent amount of marks for answering that question. So instead of maybe getting 5 extra marks on question number 1, you may be able to get 20 marks on question number 3 for just getting in the ballpark. So really by doing that, you're basically meta-strategizing through time management and ensuring that you're playing to the strength of the bell curve rather than letting the bell curve play you. I hope this video was helpful. If it was, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.